Good morning, ladies and gentlemen. Thank you so much for joining us. I'm Tamsin Kaplan, and I'm here with my law partners, Larry Casey and Gary Feldman, to fill you in on everything you need to know to avoid disaster. So stay tuned. We're going to cover a fair amount of material today, and we encourage people to ask questions as we go along. At a certain point, though, if we get into too much discussion, we may defer questions to the end. On behalf of the whole law firm, we welcome you. Some of our colleagues are here today. I see Kendra Kincherf over there. Hi. Craig Levy, who's currently at Looney & Grossman, but he's going to be joining us on May 11th as our new associate in the employment and litigation sections. Dave Rogers, who's also speaking. Will you stand up and just... You'll hear from him later. We have Michael Mom, maybe you've heard of him. the often imitated but never duplicated. I like to say Michael Mom. Anyway, as always, we have the famous Davis, Mom, and DeAugustine money back guarantee. So if you don't learn something this morning, I promise you your full admission costs will be returned to you. Oh, Amy McKendry is there. Hey, Amy. And I want to thank, sorry? Laurel Millette. Okay. Laurel is in our Trust and Estates Department. Anybody else?
Not that I see.
I'm sorry. I had a list, but then I realized the list wasn't accurate. So I want to thank especially Joanne Thorid and Erin Gange, who are in the back. They're our marketing department, and they're phenomenal. They prepare these things, they promote them, they put together all the materials. They even set up the chairs and the food, and we're very grateful to them. So without further ado, I'm going to introduce Larry, and he'll get us started. Thank you so much again for being with us today.
So I'm the opening act. It's going to get better after me, like any concert. So with regard to the act relative to domestic violence, is anybody here aware that this act exists? Okay, we got a couple of ringers. So what we're going to do is ask you some questions on the true-false. And the first one is with regard to this act, whether it requires, is this a true statement? Does it require employers with 50 or more employees to provide up to 15 days of unpaid leave in any 12-month period to employees impacted by domestic violence? True or false? How many people think it's true? And the rest of you think it's false? Well, the answer is true. So it does only apply if you have 50 employees or more. Under the Act, the question is whether an employee may be eligible for leave if the employee or a family member is a victim of abusive behavior, including domestic violence, stalking, sexual assault, and kidnapping. And how many of you think that it's true that an employee or family member, if they are a victim of abuse, the employee is entitled to get leave? Okay. You would be right. So a family member is very broadly drafted, and one thing that's not highlighted here in the definition of a family member is it includes a fiancé or a person that's in a relationship, a substantive relationship, and living together. So you can see the extent here. It's a spouse, parent, stepchild, sibling, grandparent, grandchild. If any of those individuals are victims of abuse, the employee who's related to them can get time off to deal with the abuse. The employee must provide documentation, and the statute gives specific examples of the type of documentation that can be provided in order to establish the right to leave. And again, that's if the employer requests it. So the employee doesn't necessarily have to come forth and give it, and the employee may be able to take the leave prior to giving you notice and then follow up with notice. So now what's the significance if there is a failure to comply with the statute? And the question is, does the employee have a right to file an action against the employer for violations and get injunctive relief or damages, including lost wages and benefits? Which of you out there think that this is true or false? Who thinks it's true? Nobody? All right. All you think it's false, that the employer has no rights to sue you if you violate the statute? Well, it's true that the employee can. It's similar to the same rights you have if an employer violates a wage statute and fails to pay wages. The employee is entitled to sue, and if successful and prevails, entitled to recover treble damages based on lost wages and other benefits, and recover attorney's fees and the cost of litigation. So that's a brief snapshot of the Act. Any quick questions before I pass the baton? Yes?
Is that Massachusetts or federal?
This is Massachusetts. Applies to Massachusetts employers. Who's next?
I think I'm next. Good morning, everyone. Thank you, Larry. For those of you who have been here before, you may notice that Larry Casey's new to our firm, having joined us in the last year. Today's our biggest turnout for our annual event. Larry likes to think it's all because of him. I tend to agree. So thank you, Larry. I'm going to now talk about the Parental Leave Act. Okay, so Massachusetts for many, many years has had a maternity leave statute on the books, which by its terms applied only to females. And it was over the years creating a lot of uncertainty as a matter of law. I think it was in 2008, the MCAD took which is the Mass Commission Against Discrimination, the agency that enforces the discrimination laws, took the position that the statute was violated, constituted gender discrimination because it was not gender neutral on its face. It only applied to women, didn't apply to males whose had a birth or an adoption in their family. Courts weren't agreeing with the MCAD, so the whole issue was a bit up in the air, and it was hard to give advice about it. And fortunately, the General Court, the legislature, stepped forward here in Massachusetts, as in many states, and amended the statute, which went into effect within the last several months. And it's now called the Parental Leave Act, and it provides parental leave for both mothers and fathers for the birth, adoption, or placement of a foster child in the home. So, first true-false question. Parental leave is now available to every employee in Massachusetts. Who thinks that's true? You? Who thinks that's false? The rest of you are uncertain, not brave enough to take a position. That is false. The parental leave law applies only to employees who work at a company of 6 or more employees. And so that's the employer definition size. And to be eligible for parental leave, you have to have either completed a formal probation period not to exceed 3 months or 3 months of employment. So day one you walk into a job, you are not eligible for parental leave. But a male or female who joins, who you hire at 6 months of pregnancy, has to work, or 5 or 6 months. They're there for 3 months, and if you're 6 or more employees, they will be entitled to have the benefit of the parental leave after 3 months. Before this, males could have been covered under the FMLA, which is much more stringent requirements. Employers of 50 or more, and you have to be an eligible employee, you would have had to have been employed for a full year. So this certainly relaxes the requirements, expands the scope, not just gender-wise, but in terms of length of service and the scope of the employers going from 50 to 60, although the mass maternity statute applied to the same group of people. Now, if you are an employer and both the mother and father work for your company, and they're having a baby or adopting a baby, they are each entitled to 8 weeks of leave. True or false? Who thinks that's true? Someone? Anyone think it's false? Okay, more people think it's false. False is correct. Where both parents work for the same employer, mother and father a male and a female person are entitled to 8 weeks in the aggregate. So be aware of that. That creates a little bit of a record-keeping problem for the employer in terms of keeping track, because they're allowed to, we'll just use mother and father to be simplistic about it, they're allowed to break up and divide up the 8 weeks between them. So you HR people or your HR department, because you've got benefits issues and medical insurance coverage issues, it does create a bit of a HR nightmare where you've got both husband and mother and father working for you, and you've got to keep track of how they're dividing up the time.
Do the periods have to be consecutive, or can they do a tag team approach?
Well, it's 8 weeks from the birth, so they can. There's nothing that they can do one. They can alternate weeks, which would be the worst nightmare for HR, just in terms of keeping track of benefits and pay issues. Okay, the employer is not required to provide the cost of any benefits, plans, or programs such as health insurance during the parental leave. So as the employer, you're not required to provide the cost of benefits during the parental leave. Who thinks that's true? One person thinks that's true. Everyone else thinks it's false. That's true and false. Trick question. So you were all right. The employer is not required to pay its share of benefits for the parental leave unless, bolded, unless the employer provides such benefits to all employees who are on leave of absence. So if your company has a policy of continuing to pay the employer's share of health insurance, for instance, to employees who are out on leave, then you are obligated, it would be a discriminatory act to not provide those same benefits to someone out on parental leave. Okay, so your employee comes to you, whether it's the male or female, and says, I'm going out. First of all, I'm going out on parental leave. I got a due date of such and such a date. You know, it's our first child, or maybe it's their second child. I'd like to take more than 8 weeks of leave, which is a common request. People face that all the time. Someone wants 3 months, 4 months, 6 months. They want to take more than 8 weeks of leave. So under the Massachusetts Parental Leave Act, if the employer agrees to provide more than 8 weeks of parental leave, the employer remains obligated to provide the employee all the benefits under the law, such as job security. So let me just take a step back. The purpose of the law, the main benefit of the law, is that for someone taking parental leave for 8 weeks, or under parental leave under the statute, you have job security. They have to come back to their same or similar position if there's been any economic disruption. So when your employee comes to you and say, I want to take 12 weeks or 6 months, if you agree to that, you then remain obligated to hold their job and provide them job security for the entire length of the agreed upon leave. Who thinks that's true? We got one person think that's true. A few people think that's true. That is false. The employer, sort of true and false again, so I'll give you all the benefit of the doubt on that, because the employer may deny job security and protections only where the employer has clearly provided notice in writing to the employee that they can have the extra leave, but their job may not be protected beyond 8 weeks. So if you have a verbal agreement, you tell the employee, yes, you could take 4 months, you could take 5 months, you could take 6 months, unless you put it in writing that, but we're not protecting, we're not guaranteeing you your job back after 8 weeks, and you just have a handshake deal on that, you will be obligated to provide the protections of the Parental Leave Act, primarily job security, when that employee returns in 4 months, 5 months, or 6 months. So if you want to protect yourself for someone who's going to be out on an extended leave, extended maternity leave, and give yourself the flexibility to say, you could do that, but I can't guarantee that I'm holding your job, you have to clearly articulate that in a written document before the employee goes out on leave. Yeah, question?
Hi. Thank you. What if the person's been there longer than 3 months, they've satisfied the FMLA requirements? Can the FMLA kick in and can they use that as a...
Yes, they would run concurrently.
Okay.
Okay.
if they satisfy the FMLA requirements.
Yes,
They've
if they're
just been there for the
FMLA eligible for all that.
Okay,
You want it.
so then we'd be required to protect their job for an additional 4 weeks under the FMLA, is that right?
That is right.
Okay.
Yep, for 12 weeks under the FMLA. And you could, just a heads up, you could have a situation if someone, if there's a pre-delivery pregnancy-related disability, then the employee would be entitled to either FMLA or ADA type leave leading up to the birth. If there's a medical pregnancy condition, still then would be entitled to their parental leave following the birth or adoption of the child. So parental leave is not required to be paid leave. Who thinks that's true? That's correct. It is true. Parental leave may be with or without pay at the discretion of the employer.
Carrie, I have a question. What if a company has a pay practice of paying the woman 100% of her pay? During that 8 weeks, will they now need to pay the male?
If the male is taking, so if the employer pays 100% of the mother's or the woman's pay during maternity leave, I think you would be running, I think you have to apply that in a gender neutral basis, because it would be gender discrimination to say you can, but you can't. We'll pay you, we're not going to pay him, based solely on because you're the mother and you're the father. So that's it for parental leave. Just some final points. Employees are required to give 2 weeks notice of the expected date of departure and intention to return, or as soon as practicable if giving 2 weeks is not feasible, particularly in the case of an adoption, where you could be told on a 24-hour notice that your adoption has come through. And the law expands the notice requirements. Employers must keep a posting in a conspicuous place describing the law's requirements and the employer's policies as to parental leave. Tamsin.
Someone asked a question about FMLA. Just to be clear, parental leave, as Gary mentioned, is 6 employees or more. FMLA kicks in when you have 50 employees or more within a 75-mile radius.
And you have to have been employed for the employee a year.
For a year.
So this covers...
And worked at least 1,250 hours in the year, yeah. Also, Gary mentioned that there's no what they call stacking if you have a mother and a father, or mother and a mother, a father and a father for that matter, as employees who are adopting or having the same baby. And what's interesting is that with twins, you do get to stack. You get the 8 weeks for each baby. I don't know about triplets.
Triplets too. It's in the regs. So this were in the regs under the mass maternity statute. The regulations issued under the mass maternity statute provided 8 weeks for delivery of a single child, 16 weeks for a twin, and 24 weeks for triplets. And it's presumed that those, although the parental leave statute doesn't specifically state, and there aren't any regs, it's presumed that those that provision will carry forward.
Okay, so moving on to something that's called the new Domestic Workers Bill of Rights. And this does not apply to your workplaces, but we thought it might be something of interest to those of you who have housekeepers or nannies or whose friends do. Under the new Domestic Workers Bill of Rights, house cleaners, home health workers, child care providers, and elder care providers have increased rights. Is that true? That is absolutely true. It does not include occasional babysitters who average less than 16 hours a week, or the kinds of health aides that are provided by Medicaid, Medicare, or under Mass Health. But as of April 1st of this year, Massachusetts became only the 4th state in the United States to extend employment protections specifically to domestic workers, workers in the household. And the new law is extensive. It includes provisions relating to rest periods, pay, record keeping, privacy, performance evaluations, sexual harassment and discrimination, termination and retaliation. And there is a notice that's required to be given to any household employee who works on average 16 hours or more per week, and that notice is included in your materials. Just a few highlights of the new law. 1 day of rest per 7 days if the worker works more than 40 hours in a week. Paid meals, rest times, and sleeping times depending on the numbers of hours worked. There's a specific provision for privacy in the household, even if someone is a live-in. The employee can request performance evaluations, and you must provide them. They are entitled to earn sick time. They are entitled to parental leave. They are entitled to 14 days of notice of termination, 30 days notice of termination if they're a live-in. Again, written notice of the legal rights, and you have that. And unemployment insurance, workers' compensation, protections from discrimination, harassment, and retaliation. And I recommend if you or someone you know needs information about their household employees, that they go to the Attorney General's site. The Massachusetts Office of the Attorney General not only has the notice that I've given you, but also lots of forms that can be used, such as timesheets by household employers. So this is important. Obviously, everybody needs to know about it. According to the state government, this affects at least 67,000 workers in Massachusetts. One of the interesting things about the law, and I think this is one of those funky things that will be worked out over time, is that under this new state law, these rights are, the employee in the household is entitled to these rights regardless of their immigration status. And yet, of course, under federal law, you would have to get an I-9, and you could only employ someone who is eligible to work in the United States, presumably who has immigration status that entitles them to the job. So the state is saying you can't discriminate against somebody and deny them these rights because they don't have, because of their immigration status. But of course, federal law is saying you can only employ them if they have it. So it'll be interesting to see how that plays out. But bottom line for now is definitely make note of this. Tell your friends. It's already in place as of April 1st. I have several clients who have, some of them numerous household employees, and this has been a huge, huge change for them. Okay. There's something called cat's paw liability, and I'll explain to you how that term was derived in a minute. Employers may be subject to cat's paw liability if the decision to terminate an employee is based on information, even true information, that has been reported by a supervisor with a discriminatory or retaliatory motive. That is true. And this is a little bit scary for employers, but please take note. Under this theory of liability, a good faith decision by an employer to terminate an employee or take any adverse action against an employee may be tainted, may be unlawful, if the information on which that decision is based was provided with an employee with unlawful motives. The Supreme Court has spoken on this, the First Circuit has spoken on this. Cat's paw liability is from a fable where a cunning and hungry monkey wanted to eat chestnuts that were roasting in a fire and persuaded a cat to reach in with its paws and retrieve the cooked chestnuts. And the cunning monkey then, of course, dined on these sumptuous chestnuts while the cat was licking its scorched paws. So the analogy here is that a supervisor or coworker who's the cunning monkey might give you information about an employee to persuade you as the guileless cat to reach into the fire and terminate that person or make adverse or provide or take some adverse action against them. You do that, you get burned, even if your motive is completely in good faith. So what's the message? The message is be super careful, obviously. If you get information from a coworker or a supervisor that is a basis for adverse action or termination, you are required as the employer, as the decision maker, whether you're in HR, you're an owner, you're the CFO, whoever is responsible for making employment decisions, to fully investigate. Not only make sure the information is true, but make sure that other people, other workers who have committed similar infractions have been treated the same way that you're treating this employee. In the new case in the First Circuit that came down recently, what happened was that it was true that the employee who was ultimately terminated had falsified their timesheets. they were putting more time on their timesheet than they were actually working, 15 minutes a day, which obviously adds up. And the supervisor turned them in. The employer terminated them accordingly. The employee then brought a suit saying, well, wait a minute, although that was true, and I don't deny it, my supervisor gave you this information because my supervisor was angry at me and wanted to retaliate against me for using my protected rights under the FMLA. My supervisor was annoyed that I took time off. Now, as it turns out in that particular case, they were not able to prove, the plaintiff was not able to prove the unlawful motivation by the supervisor. But the court confirmed that should the employee be able to prove unlawful motivation by the supervisor, providing the information on which the decision to take adverse action was based, if the employee could prove that unlawful motivation, then even though the decision maker and the employer made the decision in good faith based on information that was true, they still could be held liable for the unlawful motives of the person who provided that information, the cunning monkey. So please, as always, I just warn you, be super careful. Do your own investigation. Make sure similarly situated people are being dealt with in the same way.
So this is a statute that is not yet in effect. It'll be effective July 1, 2015. It's called the Massachusetts Sick Leave Act, and it's a Massachusetts law applying to Massachusetts employees. The regulations, draft regulations just came out. I'll talk about a little bit about that at the very end. What essentially the act does is it requires an employer to provide employees with sick leave. And certain situations it's paid or unpaid. So the first question is whether this act, which is effective July 1, applies only to employers with 11 or more employees. Which of you think that question is true? Okay, well, you would be wrong. It's false. So the significance of this act really depends upon your number of employees. So if you have employees that 11 or more, and that includes, you count your part-time and temporary employees, you have to provide up to 40 hours of paid sick time. So that's paid sick time if you're 11 or more employees. If your employees are less than 11, you have to still provide up to 40 hours of unpaid sick time. So this statute impacts all employers, regardless of size. Up to 40 hours of the unused sick time, paid or unpaid, can be carried over by the employee. So the way this sick time works is it accrues over time. So when the employee starts working, it starts to accrue. In this instance, since the statute doesn't come into effect until July 1, that's when the accrual will start with your current employees who have been there for at least 90 days. If you've been there for 90 days, on July 1, they start accruing. If you've been there for less than 90 days, then they have to work in the 90 days starting July 1. And the 90 days is important, is that the employee cannot take the leave until after the 90 days. So they've accrued at least some sick time. And the accrual is based on a number of hours, and it's based on 1 hour for every 30 hours that the employee works. If you're talking about exempt employees who aren't punching in and punching out, they're deemed to be working 40 hours a week. So that's how you would calculate their 30 hours, unless there's, you've got some arrangement or agreement with the employee, although they're exempt, they're working less than 40 hours, well then you'd use that number of hours. An employee may not use sick time for the physical or mental illness, injury, or medical condition of the employee's child, spouse, or parent of a spouse. So the question is, which of you think that this sick time is limited only to the employee caring for the employee's sickness or illness? Who thinks that this is true or false? Who thinks it's true? You'd be right, it's false. So a employee, this is much more narrow than the domestic violence statute that we talked about. It does only apply to the employee or the employee's dependent child. But you can take the leave for a normal sick visit, to take the child to the doctor or to yourself, to care for again, the employee or self. And then, interestingly, there's a link back to the domestic violence statute, which is that you can take leave to address the psychological, physical, or legal effects of domestic violence. The difference between these two statutes is this is narrower in one respect and broader in another. It's more narrow in that you can only take the leave for domestic violence for the employee or the dependent child, whereas I mentioned in the other statute, it was a much broader category for which you could take the leave. It's broader in that it applies to employers who have less than 50 employees. If you remember the first statute I talked about, you had to have 50 or more employees. This virtually applies to every employer. It depends on whether it's paid or unpaid, whether you have more than 11 or more employees or less than 11. The next question is, may the employer require certification of the need for earned sick time from a healthcare provider only when the earned sick time period covers more than 24 consecutively scheduled work hours? So do you, can you require certification if the employee is just out one day? Who thinks this question is true? It is true. So essentially, the employee has to be out 3 consecutive work periods of up to 24 hours before you can require certification. And you cannot delay the taking of sick leave because you don't have the certification. And you may not require that certification describe in any detail the nature of the illness, or if it's for domestic violence, the details of the domestic violence. Essentially, you can get a medical note that's simply from a healthcare provider that simply excuses the employee that they had to take time off from work, and that's going to be sufficient for that employee to take the sick time. Again, what's the harm if you violate the statute? And the question here is, employees that violate are subject to criminal and civil proceedings brought by the Attorney General. Who thinks that's true? It is true. This has some very weighty problems. If you violate it, you can be found civilly or criminally liable by the Attorney General, as well as the employee also may bring a civil action against the employer, again, getting treble damages, attorney's fees, if the employee is successful. A couple other points that I'd like to make is with regard to notice to the employer, what type of notice has to be provided. The statute requires that good faith effort to provide notice in advance be made. That doesn't require it. I'm going to go through the regs in one quick second, but I believe the proposed regulations provides that the employee should at least give notice within 30 days after they take a leave that they didn't give pre-advance notice for. The employer can provide a more beneficial sick pay provision if it wants. And you can require the employee to use that leave before using the leave under the statute. But the leave that you provide has to accrue and be used for the same purposes. So it has to accrue on at least a 1 hour per 30 hours rate, and that they can use it for themselves or their dependent child. And you have to provide notice to employees. You have to post a notice in a conspicuous place, as well as give the employee written notice of the rights under the statute.
How does the statute dovetail with the company's pre-existing policy of use it or lose it sick time?
This can be carried over. At least 40 hours can be carried over year to year.
So from a keeping standpoint, you have to keep separate records?
Correct. Well, what you would do, and I don't know if your policy is structured so that it accrues on a more beneficial basis than this one. Because if it does, then you can substitute that, but they still get to carry that over. And if it's, again, this is in the regs, but if it's paid or unpaid, you could have an employer that's more than 11, so you start out with paid. And then you lay some people off and now you're under 11. If the employee carried some time over from the prior year that's paid, that remains paid, even though now the employee is accruing on an unpaid basis because you're under the 11. And then the employee can use the paid leave before the unpaid leave. Yes.
How does PTO work? So if we have 14 PTO days, how would that work?
Okay, again, it's either going to be in addition to, or it can be used in lieu of this. If it's developing on the same rate and for the same purposes, you can substitute the PTO. If not, you can then this would be applying with regard to the leave that the employee takes.
When you think about the cottage industry of lawsuits that have come up in connection with violation of overtime payments and failure to pay minimum wage, do you see the same potential explosion of cases for inadvertent violation of the sick time regulations?
Well, I think there will be a lot of potential litigation, whether it's inadvertent or intentional. But I think, yes, if people aren't familiar with this and aren't giving the requisite number of hours and don't allow carryover, you could definitely have a...
Do they get attorney's fees and treble damages for this?
They do. They do, if they're successful in prevail. It's under the same statute as the wage claim statute.
What if an employer is union and non-union workers? And the union workers do not get sick time right now under the collective bargaining agreement? Is it preempted?
That's an interesting question. The statute says all employees, applies to all employees. There isn't any distinguishment in the statute between union and non-union. So I would, depending on what side of the equation I'm on, you maybe have somebody arguing that because you've got and again, it depends. If you've got the collective bargaining agreement, it accrues at a rate similar or better than this, and you get the same at least 40 hours or more, then that's the substitute. So you wouldn't have, that would be the substitute instead of this. That would cover it. So you wouldn't have both. Yeah. Okay, go ahead.
So just to clarify, so I want to get rid of the paperwork side of the accrual. Speak it up. I'll give them the 5 days. At the end of the calendar year, we run a calendar year. December 31st, they lose it all, but January 1st, they get 6 days to start. Am I legally covered since they're not accruing it? They can't use more than 40. Yeah.
Well, so the problem, under the scenario you just painted, so they've got the 40 hours on December 31st. You want to wipe the books clean, and then the next day, they now have the 40 hours back. Well, I wouldn't structure it that way. I'd structure it as a carryover because that's what you don't want to get into confusion that you didn't. So I would structure it as a carryover. The other issue you run is, what if I have only 15 hours that I'm carrying over? So I carry over 15, and then you don't have to give me the additional to get me to 40. So I would have to accrue that. You'd be giving me better. Now you could do better and provide better, and then that would be the substitute for this.
So with the carryover, Larry, does that allow employees who haven't used, say in year one, didn't use any sick time, to stack the carryover amount onto year 2 accrual of sick time, so they end up, say, with 80 hours of sick time available in year 2?
The most you can carry over is 40 hours, and the most you can take in a year is 40 hours. So you can't stack. So you start that year with 40, and you take 10 down. Now you're 30, and you start accruing to get back up to 40 again. Yes?
Does the employer have the option to buy them out at the end of the year as opposed to carrying it over?
No. In fact, the regs talk about that. One interesting thing is this applies to employees who according to the regs, primary workplaces in Massachusetts. And you can be working less than 50% of your time in Massachusetts, and it applies. So if you worked, you're a painter and you work in Rhode Island and New Hampshire, as long as you have a significant amount of work in Massachusetts, it would apply.
You said one about your comment about notification. You said it can happen 30 days after the absence?
Well, the statute requires a good faith effort to do it in advance. When I looked at the regs this morning, because they were just published, there was a reference to the fact that if the employee provides notice within 30 days, that would be considered appropriate.
Okay, I'm going to talk about medical marijuana and employment, one of the most complex topics you could have with very little answers to any questions you may have about it. I know there are a number of you who were here when we did our last employment law seminar in June of 2014. I spoke about this topic then. You may or may not recall what we've discussed. Since we're talking about marijuana, I won't draw any adverse inference if you don't remember what we discussed. But it's incredibly complex, and my apologies, I had a fact sheet that was supposed to lead off before we go into questions. So let me just give you some facts about marijuana, both legal and medical. Medical marijuana is now authorized in 22 states plus the District of Columbia. So for those of you who operate throughout New England, there are medical marijuana laws on the books in Massachusetts, Maine, Vermont, Rhode Island, Connecticut, New York, and New Jersey. As you all probably know, recreational use, legalization of marijuana is permitted and available in Colorado and Washington states. And in addition, voters in Alaska, Oregon, and DC have approved marijuana for recreational use, although those states have not implemented those laws yet. So we've got 22 states with medical marijuana, and now 4 states plus the District of Columbia which have legalized recreational use of marijuana. The reason that this is such a complicated area for HR and employment law is that marijuana possession and use is still prohibited under federal law. It's still classified as a Schedule I drug, and that creates a conflict between federal and state law in those jurisdictions which have legalized medical marijuana or recreational use. In December 14, Congress did pass a spending bill which prohibits the Department of Justice from using federal funds to prosecute users, growers, or distributors of medical marijuana in those states who have legalized or decriminalized marijuana. So the DOJ does not have any funding to prosecute if you are using, growing in compliance with the law of the state in which you are operating. That provision, it's a spending provision. It expires in September of 2015. Who knows what's going to happen with Congress, what the Congress will do about it then. But nothing in that provision addresses the interaction between federal employment law, such as the Americans with Disability Act, in which you need to provide a reasonable accommodation for someone with a serious medical condition, and medical marijuana. And that's really why there's such complexity. It's such a complex area of the law now that, as Joanne, who doesn't only do our marketing and help us with this, she does our legal research sometimes too, let me know yesterday that law schools are now offering courses at law school in marijuana and the law, both medical and recreational use of marijuana. And it goes way beyond just the employment aspects of it, because you've got, since the federal government doesn't recognize marijuana as in any capacity, you've got IRS issues. If you're running a business, you don't get to take the business deductions. You've got banking issues. A lot of dispensaries are operating on a cash-only basis. So the issues that have been raised by this and by the dichotomy between federal and state law are substantial. I'm going to limit it to employment issues. I've only got a few minutes, but right here it's very complicated. And we really, at this point, there's not been enough case law to work through, so we really don't have a lot of answers for you. So let's start here. Anyone who saw this slide last year can answer. So your employee comes in and tells you that he or she has a medical marijuana card. They're registered in Massachusetts for medical marijuana, and they need to smoke a joint every day at lunch because they've got a medical condition. The employer is required to accommodate the use of medical marijuana at work during the day as a reasonable accommodation. Who thinks that's true? Good. No one thinks that's true. That is false. The medical marijuana statute in Massachusetts explicitly states that an employer does not need to accommodate an employee's use of marijuana at work. But notice the language. Nothing in this law requires any accommodation of any on-site medical use of marijuana in any place of employment, school bus or on school grounds. So that begs the question then, an employee who has a medical marijuana license in Massachusetts for a serious health condition uses marijuana either in the morning before going to work or off premises during lunch hour. That license, that exception there in the Massachusetts statute does not apply to that. And just a heads up, some of the other states in New England that I mentioned, I think particularly Connecticut and Rhode Island, I'll have to check on that, specifically do have some provisions for accommodating marijuana as a reasonable accommodation. But there are no state laws that permit an employee to bring marijuana to work, to use marijuana at work, or to be impaired at work. The Massachusetts statutory provision only mentions on-site use in any place of employment, so that leaves open, there are really two huge questions. What does federal law provide under the Americans with Disabilities Act? And what about off-work use of medical marijuana and a positive drug test? You may know that marijuana, an individual may test positive in a drug test for marijuana use for several days, if not weeks, after using marijuana. So the fact that there is a positive test result for marijuana does not necessarily imply that someone is impaired at work. So what does an employer do with an employee who's got a lawful right in Massachusetts to use marijuana as a medicine and test positive in a drug test? That question is unanswered for the vast majority of employees. I will get to one class of individuals for whom the answer is clear. So under federal ADA law, an employee is entitled to use medical marijuana as a reasonable accommodation. Who thinks that's true? Does anyone think that's false? Okay, false it is. So far, all federal courts, and there's been only a handful of decisions and some further cases on appeal, have addressed this issue in states that have medical marijuana laws have concluded there are no rights under the ADA. So as a matter of the ADA, where you know you have to provide a reasonable accommodation for someone who's a qualified handicapped person, under the federal statute, you do not have to accommodate medical marijuana use. There's a case in Colorado that's being followed that's been argued to the Colorado Supreme Court. The fact scenario is sort of perfect to get some analysis. You have an employee in this case, in a non-safety sensitive position who's paralyzed, has lost the use of her legs, uses marijuana to control very painful muscle spasms in her lower extremities. There's no question about her medical condition. There's no question that she's not in a safety sensitive position, and she doesn't use marijuana while at work. So the employer, she failed the drug test. The employer terminated her. That was upheld on appeal to the intermediate court in Colorado, and that case has now been briefed and argued in the Colorado Supreme Court. We may get some guidance. At least it would only be for Colorado. It's not a matter of federal law. And the other complication to that, Colorado has a fair use statute. Massachusetts does not, but some states and some New England states, I believe, have statutes that were lobbied for by the tobacco industry that prohibit employers from punishing employees from engaging in lawful activities outside of the workplace. So Colorado has such law. One of her arguments, the employee's arguments in that case, is that she's being punished for lawful conduct outside of the workplace. So people that follow this are waiting to see that decision. Now, here's a specific class. Your company employs DOT-regulated truck drivers or other safety-sensitive transportation employees. I don't know how many of you have pilots, school bus drivers, truck drivers, train engineers, any transportation, safety-sensitive transportation employee who tests positive for marijuana. The employee claims that the use is medical, authorized under state law, and not being used during work hours. The employee must be terminated. Who thinks under that scenario the employee must be terminated? 2 people do. 3, the answer is true. The DOTs drug and alcohol testing regulation does not authorize medical marijuana under a state law to be a valid medical explanation for transportation employees' positive drug tests. So that's an absolute. If you've got any DOT licensed drivers, transportation operators who test positive, you must terminate them. Doesn't matter when they're using, doesn't matter whether they're impaired, actually impaired on the job. The DOT has a blanket prohibition. That's probably the clearest guidance we can offer you.
Hey Gary, what about a non-DOT regulated person, like an automobile salesperson or a technician?
If your company, if the company has a drug-free workplace policy, at this point you can terminate, and someone fails a drug test, I would be comfortable advising you that with a failed drug test, even in a non-safety sensitive position, or a salesperson who's like, I guess, did you say an automobile sale? Sure. Well, at this point, you would be, I would advise that you can do that. But the risk is that we haven't had any cases where someone's claiming a handicap status, who's in a if they're in a safety sensitive position, however you define that, and I advise car dealers, and we treat their salespeople as in safety sensitive positions because they're driving cars. They're taking people out for test drives, they're moving cars around a lot. So in that scenario, we would consider anyone who's operating a moving vehicle, a forklift in the warehouse, any sort of motorized equipment, any heavy machinery, safety sensitive position. Currently under the law, you are, I think, in safe spot to terminate for a positive drug use, even though the reality is that a positive drug test does not imply impairment on the job because of marijuana. If it was any other drug, it would be, but the peculiarities of the chemistry of marijuana doesn't necessarily mean that they're impaired on the job. I think where you get into trickier difficulty is with an employee who's in an administrative position or clearly a non-safety sensitive position who is licensed in Massachusetts for medical marijuana use. You clearly do not have to allow medical marijuana use during working hours at the job. If the employee comes and tells you I use in the morning or I use at night, of course I'm going to test positive. I'm an admin, I'm something else, I'm a receptionist, I'm in some position. That's going to be a trickier call, and we just don't have any guidance from courts anywhere on that. Yes?
I was just going to ask you about that, Gary, to say, is there any place in the country that the case is rising high enough to reconcile this? This is clearly not going to get reconciled until it gets up, probably the Supreme Court. Somebody's going to have to reconcile this gap between the federal and state law.
Well, nothing, I'm not aware of anything that's gone on to where a petition of cert or where the Supreme Court, U.S. Supreme Court has addressed it, but there are several federal court cases which have been decided strictly under the federal ADA law. Like I said, and every one of those cases have come down that medical marijuana use is not a reasonable accommodation under federal law. And whether that gets, I'm not aware of whether those cases are on appeal or the status of those cases. I mean, like I said before, the one state court case that is now waiting a decision by a state Supreme Court is Colorado. But that could end up getting decided on the Colorado Fair Use Statute, which really wouldn't give us in Massachusetts any guidance because Massachusetts does not have a fair use statute. So I could go on and on about medical marijuana. Like I said, it's very complicated. We don't have enough answers yet. But the reason we did this again is when I was here last year talking about this, there had not been, no dispensaries had yet opened, been licensed and open in Massachusetts. If anyone follows this, the Department of Public Health, it's been a complete embarrassment and disaster. As a citizen of the Commonwealth, I take it personally embarrassing what a joke the Department of Public Health has been in implementing the referendum, and there's been litigation all over the place. But as of now, I think the first dispensary has opened, and several more, if they're not already open, are due to be open every day, any day. So you may, as employers, may start seeing this more and more because now dispensaries are up and running, finally. Any other questions that I won't be able to give you answers for? Feel free, though. Other than, if not, I'll turn it over to Tamsin.
Moving on to Pregnancy Discrimination Act. In federal law, we have the Pregnancy Discrimination Act, which is part of Title VII. It's a type of sex harassment, gender harassment. and gender discrimination. Under federal pregnancy discrimination, an employer is automatically required to provide the same accommodations to pregnant workers as to disabled workers with the same work limitations. Actually, this is false because last month in Young versus UPS, the Supreme Court said they're not automatically required to be given the same accommodation as someone who's disabled, but if they're not given the same accommodation, there has to be a legitimate business reason for that distinction, why the two people are being treated differently. The U.S. Supreme Court last month determined that this automatic right does not exist, but made clear that employers may treat pregnant workers differently only if there is a legitimate reason for the different treatment. So in Young versus UPS, we have a pregnant woman who has a lifting restriction from her doctor. She can only lift up to 20 pounds. The job requires lifting 70 pounds. UPS has a policy of automatically providing an accommodation, a light-duty accommodation, to 3 categories of people who are not able to meet the 70-pound lifting restriction. And those are people who are disabled under the Americans with Disabilities Act. They're limited in their major life functions. Number 2, those who have suffered on-the-job injuries. And number 3, people who have lost their certification under Department of Transportation requirements. Other than that, there's no specific policy. And so it's the accommodation, the light duty, is provided to employees who are not in those 3 categories on a case-by-case basis. So the pregnant plaintiff here, the formerly pregnant plaintiff, I'm sure by the time she gets to the Supreme Court, says, well, under the Pregnancy Discrimination Act, I was not treated fairly because I should have been treated the same way as anyone who is entitled to accommodation as a disabled person. The Supreme Court says, no, you're not automatically required to the same treatment. However, they remanded to the circuit court and said, we agree with you that they're not automatically entitled to this accommodation, but we need to send it back to you because we need to send it back down because we need a complete analysis of whether there is a distinction based on pregnancy between the way this worker was treated and the way other workers with similar limitations have been treated. So they look at whether similarly situated people are being treated the same, which is a theme you've heard before, or the plaintiff would have to prove that she was not provided with this accommodation because of discriminatory motives based on her pregnancy, which is a type of sex discrimination. Now, as you know, in Massachusetts, we have Mass General Laws Chapter 151B, under which pregnancy discrimination is a type of sex discrimination. This is a federal case looking at the ADA and looking at Title VII rights. However, there's good and important guidance here, which is, again, a reminder to employers that you want to look at these choices in the context of all similarly situated employees. If someone is similar in terms of their ability or inability to do their job and is requiring an accommodation in the way of light duty in this case, do you provide that to all employees? Do you provide that to some employees? If you're not providing it to all employees who have that same restriction, we want to look very carefully to make sure that there might not down the road be an inference because of the facts that it's the pregnant person who didn't get the accommodation, or it's the woman who didn't get the accommodation, or any other minority classification that, based on looking at all similarly situated people, the plaintiff can show was singled out and treated less favorably. Any questions on that? Okay. By the way, under federal law, discrimination against someone because they're a caregiver of a child or an elderly family member is also considered sex discrimination. If, for example, and this would be the same in Massachusetts, under Massachusetts law, you have a man who has, say, a 4-month-old baby and a woman who has a 4-month-old baby, and there are certain presumptions or stereotypes that the employer employs in making a decision to treat the female employee less favorably than the male employee because they think, well, you know, the woman is the mom, the woman is going to give the caretaker, the woman can't do the same job as the man who has the same age child. So moving on, after pregnancy, we go to nursing moms in the workplace. All employers are required to provide nursing mothers with reasonable break time and a private room or other comfortable location to express milk for 1 year following childbirth. Is that true? Is that false? Okay. It is false because under the Fair Labor Standards Act, which many of you know is a federal law, employers with 50 or more employees are automatically subject to these requirements. They have to provide reasonable break time. They have to provide a private place that's out of view, that will not be subject to interruption by any other employee. And by the way, automatically the place cannot be a bathroom, no matter how nice the bathroom is. But employers with fewer than 50 employees are subject to these requirements only when compliance does not impose an undue hardship. So 50 or more, you have to do it regardless of how difficult and complicated it is for your operations. Less than 50, fewer than 50, you don't have to do it if it's an undue hardship. However, these obligations extend, interestingly, only to non-exempt workers. So if you have someone who's an exempt worker, who's an administrative or executive or professional worker, you're not required to provide these breaks. I think there's an assumption that someone who has that level of authority and in that kind of an exempt position is going to be able to take the time that they need to provide the breast milk for their child. All right, so if there are no questions, we're going to move on to introduce our wonderful guest, our wonderful speaker next, David Rogers. Dave is of counsel with the law firm of Davis, Mom, and DeAugustine, and he also is a state legislator. He's a state rep representing Belmont, Cambridge, Arlington, and part of Cambridge, right? Dave is my state rep. I voted for him. And now I don't know if that's true or not. In the privacy of the polling place. And now I'm delighted that he is our colleague here at Davis Mom starting last fall.
Great. Well, thank you. And so, as Tamsin said, I'm both a lawyer and a politician, and that means my mom is shaking her head every day and wondering what happened. But I'm going to talk a little bit about pending legislation. And over 5,000 bills get introduced every session, so you never know what's going to move. But as you can see from the presentation today, most of these laws passed in the last session. The Sick Leave Act, the voters did on the ballot in November. But all the other laws came through the legislature, and so I'll highlight some for you. There's not a PowerPoint presentation. It's in your packet, the 3 bills. But if you have questions on other legislation that's pending that maybe particularly affects your business, obviously feel free to get in touch with questions. The first one I want to discuss is the act relative to the Defense Against Abusive Waivers. And basically this has to do with contracts presented to an employee when he or she joins the company, waiving rights. And the main right that employees waive is the right to a jury trial. Typically, the contract would state there's binding arbitration, sometimes out of state. So say Bank of America is located in Charlotte, but they have, obviously they do business in Massachusetts. They have a Massachusetts employee waive their right to a jury trial in their standard contract. That would be illegal under this legislation. And it's both pre-employment, or if you tender that document to the employee after they've begun, again, that would be illegal as well. And it does come with a retaliation claim, meaning if the employee refuses to sign it and then there's any action, any kind of adverse action taken against that employee, it creates a claim, which lost wages, lost benefits, and the Attorney General would be able to enforce this, and the MCAD as well. The next bill is been circulating for a few sessions now on Beacon Hill, and it's a big one, and it would completely ban non-competition agreements in Massachusetts. I'll read you some of the language. It prohibits any agreement that prohibits, impairs, restrains, restricts, or places any condition on a person's ability to seek, engage in or accept any type of employment or independent contractor work for any period of time after an employment relationship has ended. So this is similar to California. California has done this. And it's funny, there's a split in the business community. I get contacted by tech companies because the people usually think of this as benefiting employees. They can protect their intellectual property and their trade secrets, customer lists. But if you think about you're the employer trying to attract someone, you're prevented. And so the tech companies are getting in touch with me saying, we favor the ban. We favor labor mobility. Other companies contact me and they're not in favor of it. So there really is a split within the business community on this legislation. And there are a number of exceptions. I think the bill is reasonably well drafted, putting aside whether I favor it or disfavor it. I think it's well drafted because, for instance, there's a carve out for a covenant that would prevent the employee from soliciting or transacting business with customers, clients, or vendors. So say you have a key sales representative and you want to say, sure, you can leave, but you can't contact customers, clients. You can do that under this legislation, which is one of the big pieces employers worry about, obviously. There are other, it does not prevent the other agreements you might have an employee sign. So non-disclosure agreements, assignment of inventions, all the other sort of range of contracts employers use to protect their intellectual property would still be permissible. And then there's a carve out for the sale of a business and certain other items. And then the final bill I'll mention is a significant bill. There's no way to ever tell what's going to move to final passage, but this has over 100 co-sponsors. There's 160 of us, so there's already a majority of the House that's co-sponsored the bill. Now, again, that doesn't mean it's going to pass, but it may have some legs. And that is the Act to Establish Pay Equity. And what this bill does, it clarifies a Supreme Court decision here in the state that the comparable work standard must be based solely on comparable skill, effort, responsibility, and working conditions. It also would prohibit employers from banning employees from talking about their pay. Right now, employers can do that. And finally, it amends the anti-discrimination statute, 151B, to mandate that job advertisements must post the minimum wage that's going to be paid for the job. It makes it unlawful for an employer to pay wages less than what's been advertised. And finally, it makes it unlawful to use salary history when you're hiring. And the theory there is if women have perennially had institutionalized forces holding back their pay, if they have to disclose their salary history, it could hurt them in a negotiation for their next job. So the good thing about this for employers is it creates a defense, which there's no other law, I think, in Massachusetts that creates a defense against wage claims. And this defense says is if you do a self-evaluation, if you look at your pay structure, if you go through your organization and try to assess whether there might be disparities in pay between the genders, and you document it, then a claim comes later, you can defend against it. So I think employers like that piece that if you take proactive steps, you can be insulated from liability. So those are some of the ones that I think are kind of hot on Beacon Hill. There are a number of other ones. Obviously, I know many of you may worry about the independent contractor statute. I get a lot of questions about that. There are a number of bills to look at some of the problematic aspects of that. So again, feel free to get in touch on any legislation. And thanks. Any questions? Or?
David, I have a question on the posting of jobs. So you're saying based on experience, you can't say anymore under this new law if one is posting for a job? Because that's a pretty common thing on a lot of postings.
Well, that's right. You mean you have to list the minimum amount you pay. So for salary commensurate with experience, gone under this bill.
Okay. And when do you expect these to be passed?
Well, again, I really have to stress, I mean, I'm in my second term, and the legislature moves in strange and mysterious ways, you know. I even talk to chairs of committees, and I'll go to them, and I'll say, you know, what's going to happen? It's in your committee. And they'll say, well, on the one hand, on the other, because there's so many forces at work with what might make it move. But the session is 2 years, 2015 and 2016. And so the House and Senate are currently in, I don't know if you've been reading about this, in a standoff over committee structure. So nothing's really moving right now. I expect that to be resolved soon, and then legislation will begin to move. So, but probably the early part of next year.
And on another thing, where do you see minimum wages going? I know they're changing dramatically. State of California has made some major changes.
Well, we just passed the highest minimum wage in the country. $9, then 10, then 11 over the next few years. But there's a movement to do living wage, $15 an hour. I think Seattle did that. Not the state of Washington, just Seattle. The speaker, I just met with him. You know, we just did a big minimum wage hike. We're going to have the highest one in the nation. I talked to him about it. I doubt they're going any higher anytime soon. Again, I can never say with certainty, but I just don't think we'll do it. Sure.
So just one clarification. Dave was talking about pending state law bills that have been introduced. And currently there's no protection as a matter of Massachusetts state law to protect workers, employees from talking about amongst themselves about their wages. But under federal law, in the National Labor Relations Act, the NLRB will will prohibit employers from taking any action under Section 7, impeding Section 7 rights of employees, whether you're a union company or a non-union company. Under federal law, you cannot prohibit employees from communicating about their terms and conditions of employment, including their wages. So I just wanted to make sure that you were all aware of that.
So I think I was confusing when you were talking about notice and documentation. So the notice is good faith effort by the employee, and if they don't give advance notice, they have to, as soon as practical, come back and give you notice that I'm going to be out. So I go into the hospital at midnight, maybe I call you at 10 in the morning or 11 in the morning, so whatever's practical. As far as documentation, the employee has to provide the documentation within 30 days. It's verifying from the healthcare provider signing saying, yes, he was out sick. He's there. With regard to the question about payoff, you can pay, now these are based on the proposed regs, which have not yet been adopted. But under the proposed regs with regard to payoff, on a payout, what you can do is you can, you're not required to, but you can offer a payout for up to the 40 hours, provided that you make available to the employee at least 16 hours of sick time beginning in the new year. So they're starting out with a bucket of time to start with. You want to do that, pay them the 40 hours or the 30 hours they didn't use, but they're going to start with 16.
How about on termination of employment? Does it have to be cashed out?
No. No. It's not like vacation.
I have a question. If your company gives paid time off like 20 days a year, do you have to track the sick time separately?
Well, again, it depends. It can substitute for the sick time under the statute if it's at least similar, if it's the same or better. They accrue it faster and they can use it for the same purposes. All right, it can cover the same. If it's different and it accrues less and maybe you only let the employee go out, not for the employee's child, then the sick time under the statute is in addition to. So I think the advice would be make them the same, accrue them at the same rate, and the employee can use them for the same purposes in the same manner, in which case it's not in addition to what's going to eat them. So if you give 20 hours, 20's gone, but they're still going to have the 20 under the statute. Does that make sense?
So they get 20 days of paid time off, and that includes sick, or you can use it for whatever.
Well,
we don't track what people use it for.
If they get 20 days, that's more than 40 hours. So long as it accrues, if you're saying they just start and they get 20 hours, they don't have to accrue it on a basis. If they get the 20 days and they get it it accrues to them quicker than, either an hour for each 30 hours or quicker than that, then it would substitute for this. And it would be more than the 40 hours. You're covered. That's all you have to track.
Okay.
Sorry for the long-winded answer there.
And to answer her point, if they say it can be used for any reason, does that sort of just make it easier?
Yes.
So it's just one clean sweep?
Yes.
So I just have a quick question about the carryover that this gentleman asked for. If you have the 40 hours and then you carry it over, he was saying he wants to stop and then just grant.
Yeah, just going to grant you the 40 hours right away.
I was assuming that you always get 40 in the bank and that you could have more than 40 in the coming year, so that essentially you could use 2 weeks during that second year. Is that not correct?
No, because you can only use 40 hours in one calendar
But
year.
but they could use it, but then, so they'd always have the 40 to carry. In your scenario, is that true?
No, no, so I'm going to basically cut them off at the end and
And
give
give
them a
it
whole
to
new
him.
bank again.
Right.
So he's,
I'm not sure if I understand your question, but I think what he was proposing is, I get an employee on December 31st and they've got 40 hours that they haven't used. I'm gonna wipe those out, and on January 1 they start with 40 hours. All I'm saying, from a structured standpoint, I would rather say you carry it over than wipe it out and add, because it just creates confusion. You're doing effectively the same thing. Under the proposed regs, you could pay them for those 40 hours, but they're going to start with 16. So you've got to, what you could do instead is pay them, and then you start with 16 so they don't start with 40. But I wouldn't want to structure it that we're wiping it out and now you're starting with 40. Now maybe that will get clarified in the regs, but right now that's not the way it's structured.
But don't they get 40 plus, don't they keep accruing or not?
My understanding, it's not clear in the statute, and they don't specify yet under the regs. It's my understanding you get a max of 40 hours. So you don't continue to accrue, because if you get to the end of the year, all you can carry over is 40, so all you start with is 40. When you use some time up, then you start your accrue to bring you back up to the 40. But you don't get up to 40, you don't get up to 80, unless you have a policy that says you can accrue and continue to accrue. There are some employers, and there are some public employers, where you can build up a sick bank. In fact, there was a recent case in Superior Court where the judge found, I think it was the MBTA, they have a sick bank. And if you retired, you get paid out that sick bank. And this judge said that's a wage. And their failure to pay it, because there was an issue about retirement, was a violation of the wage statute. So you could structure it such that I have the sick bank and I can accrue, and the employee could have 80 or 120 hours and continue to carry it over. That's much better than the statute. You're okay doing that. But under the statute, it's 40 hours. All you can carry over is 40. So if there's no more additional hours, you've got the 40. And all you can use is 40. There's no additional accrual. It wouldn't do anything. There's no benefit to it.
And what the state law does, it's the minimum. As I understand it, you can do more than what the state. So if your company has a policy, like Larry said, that you can accrue and then carry over unused time into the next year, you're free to do that. This is the minimum requirements that the employee has to get 40 hours in any given defined year. But the statute doesn't require that you then stack if someone in year 1 didn't use the 40, then going into year 2, on the Sean's example, they now have 80. If that's not the company policy, the statute doesn't require that.
The company has to manage the accrual. If they take a day in March, they have to manage the accrual and say, oh, now this person gets to accrue. Right. So it becomes very difficult to sort of manage.
No, you have to manage it. They are entitled to earn and use.
Right.
So they earn it up to 40. Now they're no longer entitled to earn anymore until they bring it down below 40.
So they use it, and then you have to figure out when that is.
Right. I mean, if you have a policy of you get 20 days PTO, somebody uses it, you're still tracking that. Here you're tracking it on an hourly basis.
But as in all these statutes, again, it sets a minimum threshold. So as long as your policy is more generous, then you're fine. The public policy reason why you're required to allow carryover up to 40 hours is because they don't want people to start the year with no available sick time and have to start accruing from scratch. So I think, technically what you do addresses it. I mean, in practical terms, what you do addresses it. But Larry makes a good point, which is that technically for purposes of complying with the statute, you want to call it carryover rather than calling it wiping it out and starting again.
And there's still, as I understand it, I'll ask you guys this, the issue of what do you do with it? If your company doesn't distinguish between sick and vacation days, and you call it all PTO. What do you do with the terminated employee who you are required to pay accrued and unused vacation, not sick time at the end? You have to treat it all as sick, right? Right. So if you don't distinguish it, if you go to, because you think in one sense it's easier to just have PTO, just be aware that at the time of termination you're paying out the full PTO bank and not just the sick time, because you haven't distinguished between the two.
Okay, well, there's still food and coffee and juice out there, so please stay. If you have individual questions, feel free. Thank you so much.
Thank you all for coming. Thank you.